Some dates quietly shape the future of a nation. They arrive without fanfare, yet their impact can ripple through generations, altering the course of history in ways few could have predicted. January 9, 2025, is one such day for the United States. On this day, the Supreme Court receives the final briefs in a series of pivotal cases that have the potential to redefine the meaning and reach of the Second Amendment. Legal teams, advocates, and citizens alike have spent months preparing for this moment, knowing that the stakes could not be higher. The justices will soon decide whether to hear challenges to a range of state gun laws. Their decision could bring long-awaited clarity to a legal landscape that has become increasingly fractured and contentious. For years, lower courts have struggled to interpret the boundaries of gun rights, often reaching conflicting conclusions. Across the country, courts have interpreted gun rights differently, creating a patchwork of laws that change from state to state. In some places, regulations are strict and comprehensive. In others, they are far more permissive. This inconsistency has left citizens, law enforcement, and lawmakers uncertain about what the Constitution truly protects. The cases before the court directly confront these inconsistencies, asking the justices to establish a uniform national standard on firearms rights. The legal arguments are complex, touching on questions of individual liberty, public safety, and the original intent of the founders. The outcome could either strengthen or restrict the right to keep and bear arms for millions of Americans. For gun owners, advocates, and families across the nation, the court's decision will have real, tangible effects on daily life, personal security, and the sense of freedom that many hold dear. This day marks a turning point in the national debate over firearms, freedom, and public safety. The voices on both sides, those calling for greater regulation and those defending gun rights, are louder and more passionate than ever, reflecting deep divisions and shared hopes for the country's future. The decision set in motion on January 9th will shape not only the legal framework, but also the cultural fabric of the nation for years to come. As the Supreme Court weighs its choices, the eyes of America, and indeed the world, will be watching, waiting to see how this chapter in the story of American rights and responsibilities will unfold. At the heart of the Supreme Court's review this term are a series of high-stakes cases that directly challenge some of the strictest state gun laws in the country. These cases have drawn national attention as they pit state efforts to regulate firearms against the constitutional rights of millions of Americans. The outcome could have sweeping consequences, not just for the states involved, but for the entire nation's approach to gun control. In Snope v. Brown, Maryland's ban on semi-automatic rifles, especially popular models like the AR-15, is under intense scrutiny. Plaintiffs argue that these firearms are among the most commonly owned in the United States, used for lawful purposes such as self-defense, sport shooting, and hunting. They claim that Maryland's law unfairly targets law-abiding citizens, making it nearly impossible for them to own firearms that are legal in most other states. Meanwhile, in Ocean State Tactical v. Rhode Island, the focus shifts to magazine capacity limits. The plaintiffs contend that banning standard capacity magazines, those holding more than 10 rounds, directly undermines the right to self-defense. They argue that such restrictions could leave individuals vulnerable in dangerous situations, and that these magazines are standard equipment for millions of gun owners across the country. Delaware's Gray v. Jennings echoes the challenge to so-called assault weapon bans, raising questions about what types of firearms states can prohibit. At the same time, Maryland shall issue v. Moore takes aim at the state's complex and costly handgun licensing process, arguing that it places excessive burdens on citizens who wish to exercise their Second Amendment rights. Across all these cases, plaintiffs insist that these laws create unconstitutional barriers to exercising a fundamental right enshrined in the Constitution. They argue that the Second Amendment's guarantee of the right to keep and bear arms should not be subject to arbitrary state restrictions or bureaucratic hurdles. These legal battles strike at the very core of modern gun control debates, challenging bans on popular firearms, limits on magazine capacity, and restrictive licensing requirements. Supporters of these laws say they are essential for public safety, while opponents see them as government overreach that criminalizes ordinary citizens. The Supreme Court's decision to hear these cases signals a willingness to revisit and possibly redefine the boundaries of state power over gun ownership. If the court rules in favor of the plaintiffs, it could invalidate major state gun laws and force states nationwide to reconsider their regulations, potentially reshaping national policy for years to come. The stakes could not be higher. Millions of gun owners, state lawmakers, and advocates on both sides are watching closely, knowing that the future of state regulation and the balance between public safety and individual rights hangs in the balance. The Supreme Court's action after January 9th will determine whether these controversial laws survive or fall, setting a precedent that could echo across the country for generations. Two landmark Supreme Court decisions, District of Columbia versus Heller in 2008 and New York State Rifle and Pistol Association versus Bruen in 2022, have fundamentally shaped the modern debate over gun rights in America, setting the stage for today's most contentious legal battles over the Second Amendment. In Heller, the court issued a historic ruling that affirmed for the first time an individual's right to possess firearms for self-defense within the home. The decision struck down Washington, D.C.'s ban on handguns, making it clear that the Second Amendment protects ordinary citizens, not just members of a militia. The ruling also rejected laws that ban commonly owned weapons, emphasizing that the right to keep and bear arms is deeply rooted in American tradition. 14 years later, Bruen expanded these protections beyond the home. The court ruled that the right to carry firearms for self-defense extends into public spaces, and that any restrictions on this right must be consistent with the nation's historical tradition of firearm regulation. The so-called Bruen test now requires that any modern firearm regulation must be justified by a clear historical precedent from the time of the founding, not simply by contemporary policy arguments or public safety concerns. These rulings have made it significantly more difficult for states to defend restrictive gun laws in court. Judges are now required to focus on the historical context of gun regulations, rather than relying on arguments about crime rates or public safety. As a result, the Supreme Court is now being asked to apply these principles to new challenges, specifically to laws that ban certain types of firearms and high-capacity magazines. These cases are testing the limits of the Heller and Bruen decisions. The questions before the court will help define just how far the Second Amendment's protections reach, and whether states can continue to restrict access to specific weapons or accessories. The outcome of these cases could either cement the broad protections established by Heller and Bruen, or set new limits on the right to keep and bear arms in America for generations to come. Despite clear Supreme Court guidance, lower courts remain deeply divided on gun rights. Some circuits have struck down gun laws lacking historical precedent, while others uphold restrictions by sidestepping the Bruen test. This has created a confusing patchwork. Gun rights can change simply by crossing a state line. Critics argue that some courts are defying Supreme Court precedent, fueling calls for intervention. The Supreme Court's review could resolve these conflicts and restore uniformity to Second Amendment law. If the court declines, legal uncertainty and unequal rights will persist across the country. Another legal battle is brewing over the right to carry firearms across state lines. In McCoy versus Jacobson, two truckers challenged Minnesota's refusal to recognize their out-of-state concealed carry permits. They argue the Second Amendment right to self-defense shouldn't disappear at state borders. The case seeks national reciprocity for carry permits, much like driver's licenses. If successful, it could create a uniform standard for carrying firearms nationwide. The case builds on Bruen, arguing that constitutional rights must travel with citizens. Even if it doesn't reach the Supreme Court immediately, it highlights the growing complexity of gun rights in America. The debate now extends beyond ownership to the right to carry across the nation. A new legal front questions whether Americans should need a license to exercise Second Amendment rights. In the Taylor-Taranto case, lawyers argue that requiring permits to own or carry firearms is an unconstitutional barrier, akin to needing a license to speak or publish. They claim licensing schemes are just bans by another name, designed to discourage gun ownership through bureaucracy. If this argument prevails, it could dismantle licensing systems and move the U.S. toward constitutional carry. No permit required. The implications would be revolutionary, challenging the foundation of gun control in many states. This bold legal theory is gaining traction, pushing the courts to treat gun rights as absolute, not privileges. The outcome could redefine the relationship between citizens and the state on gun ownership. The Supreme Court's decision after January 9th could reshape American gun rights. If the court strikes down state bans, it would set a national standard, limiting state power to restrict common firearms and magazines. For gun rights advocates, this would be a historic victory. For gun control supporters, a major setback. If the court declines to hear the cases, the current patchwork of laws and legal confusion will continue. The justices could also choose a middle path, clarifying the law without sweeping changes. Whatever the outcome, the court's action will set the course for gun rights and regulation for years to come. This is a pivotal moment for the Second Amendment and American law. The battles culminating on January 9, 2025 are about more than guns. They're about the meaning of constitutional rights in America. The outcome will affect every citizen, not just gun owners. At stake is whether fundamental rights can be limited by states based on policy concerns, or if federal law remains supreme. The court's decision could set a precedent for how all constitutional rights are treated, from free speech to privacy. Legal uniformity is essential for trust in the judiciary and the functioning of a federal republic. The debate also forces a reckoning with how 18th-century principles apply to modern society. January 9th marks a turning point in defining liberty, government power, and the rights of all Americans.